times, Trooper Seide either asked him to get out of the car or hand over his keys.
How you doing, my man? I'm gonna need you to step up, okay? We have some stuff to talk about, okay? We just have some stuff to talk about.
Every time y'all talk about,
Alright,
we got some stuff to talk about, y'all can take me to jail for what?
Okay, there's some stuff to talk about. Just arrange the time and have your stuff.
Yeah, hold on.
Now. Okay,
No, because I'll call my attorney right now. Hey, this ain't no funny shit.
Okay.
If y'all talking about that shit with Terry Young,
But you have to step up, okay?
hold on, is it a warrant?
No, it's not a warrant. I need you to step up.
Hold on.
I'll explain it all out when we get out of the car.
Hold on, because y'all think y'all some funny shit. Y'all keep it a buck with me, bro. But if y'all think y'all some funny shit with me, y'all can tell me right now. Something call out my attorney.
You hand me the keys.
Can't hang my keys.
Hand me the keys to the vehicle.
Why?
Hand me the keys to the vehicle.
Why?
Just hand me the keys.
Y'all keep it a buck with me, bro. Y'all pull me over my headlights.
Okay. Yep. I'm already past that. So like I said, you need to step out of the vehicle.
Okay, we passed that, so where we at?
Okay. You need to step out of the vehicle.
So where are we at, though?
And I'm gonna explain it all when you step out.
But when you say step out of the vehicle, you go
Yes,
explain it to
this
me.
is not a law.
Then you gotta so.
This I
15 times, not counting, this is a lawful order. 15 times Trooper Seide asked him to do that before Ryan Londregan opened up the passenger door, because as you can see, Trooper Seide was repeatedly trying to open up the driver's side door and it was locked. Yet now, she wants to come here and claim, surprised, that he was opening up a car door to effectuate an arrest. The next point, he could have done nothing. This is part of the oath that every Minnesota State Trooper takes when they take their job: to help those in danger or distress, and, if necessity arise, lay down my life rather than swerve from the path of duty. This is at the core of this matter, because it's not just this matter. She's denigrating the first responders over and over again today. These men and women are doing this every day for us. I don't want to do it. I don't think Paul, I don't think Lou, I don't think Sean, I don't think Mark, I don't think anybody in here wants to do this job, particularly in Hennepin County right now. But to ask Ryan Londregan to do nothing in this circumstance, this is another frame-by-frame analysis. Right before Ryan Londregan, now Mr. Cobb had already moved his car forward once and briefly stopped. As you can see, this is Mr. Londregan's body cam. Mr. Seide is practically in the car, and as you can see from Trooper Erickson's body cam, that is Trooper Seide right there. His knee is in the vehicle, and it was taking off. How do you stay consistent with that duty, with that sworn duty that you did, that I will not swerve from the path and putting myself in harm's way in order to protect somebody else? How do you follow that duty and just stand back, put your hands in your pockets and say, well, Brett Seide, looks like you're going to have a bad day? Unless there be any doubt here about whether or not Brett Seide was dragged, you can see in the public video, after he was dragged, what did he say? Without talking to a lawyer, without talking to his commander, without talking to anybody, what did Brett Seide say? I just got fucking dragged. Said this in court. Trooper Londregan heard Trooper Seide get a COPS alert. That stands for Keep Our Police Safe. This is an internal database that police have. This is the database where they learned that Trooper Seide had a critical hit after he put in the license plate number on Mr. Cobb that told him that there was an outstanding violation, felony violation of an order for protection. Now, what Trooper Seide didn't know at this point, Ricky Cobb had already been convicted of felony domestic strangulation. He also didn't know that he had a gun in his car. And what I heard today is that that was irrelevant. Well, do you think that might have had a bearing in why, when Trooper Londregan opened up that car door, that Ricky Cobb took off? He was a felon in possession of a firearm. And the troopers were just about to enter that vehicle and find it. For them to say now that that's irrelevant, I have spent so much time on this case dealing with Alice in Wonderland, I feel like I have been living on the other side of the looking glass. To quote the great Ron Burgundy, am I taking crazy pills here? This is me getting on my soapbox with respect to you, the media. This is the picture that we see over and over with respect to Ricky Cobb. I see it on TV, I see it in the Star Tribune, I see it everywhere. This is Ricky Cobb's tattooed leg. You can see here it says 19 Dipset Gang on his calf. What's that? Well, all you need to do is go to the Department of Justice's press releases, and you can find that the 19 Block Dipset Gang is involved in the distribution of heroin and gun trafficking. This is Ricky Cobb's, one of his 3 Instagram pages that he set up. That's the profile picture that he chose. That is Ricky Cobb. More pictures from his Instagram page. Now let's also remember here too that this is a man wanted for a felony violation of order for protection that had already been convicted of felony domestic strangulation. What else is on his Instagram page? This. Does anybody from the county attorney recognize this one iota? What I heard over and over again today is, I am so sorry. The picture that I'm hoping that all of you from the media show. This is the picture that Ricky Cobb chose as his profile picture. Respect him by putting up the picture that he chose. The county attorney today said it was hard for her to believe that Ryan Londregan acted intentionally in what he did on July 31. Ladies and gentlemen, I'm a lawyer. I've been a lawyer for 32 years. I'm not a cop. I thank God I'm not a cop. I certainly thank God that I'm not a cop in Hennepin County and have to answer to the likes of Mary Moriarty. But there's been a lot of complaining here that with respect to the defense team saying, well, they keep saying that Ryan Londregan's a hero. You're damn right I do, because he is. And the other thing that, frankly, nobody from the county attorney's office, and frankly, a lot that I have not heard, is who is Ryan Londregan, the person? And that's why I want to give you a little sketch of that, just the tiniest bit in this context. He went to St. Michael's College, GPA 3.83. Bachelor of Science in Business Administration, minor in Religious Studies. Got his law enforcement, LEDO training, July 2021. August 2021, got his post training, State Patrol Academy training. He finished on October 22, 2021. He began his solo patrol beginning on February 2, 2022. 544 days he was doing his job before July 31. 544 days. Keep that in mind as I'm talking about what's coming up. He won the Outstanding Rookie Award from Mothers Against Drunk Driving. One person wins that award. He won the hat trick recognition, that's for 3 DUIs in a shift, 4 times. A lot of troopers don't get that once. He won the DWI Enforcer Gold Pin for MAD in 2022. He won the Chief's Commendation Award for DWI Enforcement. He won the DWI All-Star Award from the Department of Public Safety. The ceremony was on August 20, 2023. He couldn't go to that. Want to know why? Too many threats against his life. The colonel said, we don't want you there because you could get hurt. DWI Enforcer Award Bronze Pin 2023. Pause on that. The DWI Bronze Award is for the amount of DUI arrests that you've done in an entire year. In 2023, Ryan and his young wife, Grace, had a little boy. Ryan took about 3 weeks off for paternity leave. Then the incident happened on July 31, 2023. He won the bronze pin while being on the job about 3.5 months. 3.5 months. This is the guy you want coming to your house when you really need a cop. It has been my honor representing this young man. Not just because he's innocent, but because this is the sort of person that puts his ass on the line for all of us. And for her to stand up in the 20-something floor of the Hennepin County Government Center and say, well, I doubt that he was acting intentionally. Yeah, that's because you've never done it. And I haven't either. But the difference between me and her, I respect them. And I respect the training, and I respect the badge. And I wish she would show just a modicum of that respect towards not only Ryan Londregan, but the other troopers as well. I heard today, and I think I saw, actually it was from KSTP, or it might have been Lou, your reporting, that the Steptoe law firm has done recommendations in a 60-page report that, as a resident of Hennepin County, apparently I have paid for. Lawyers from DC coming in and telling cops how to do their job. I would like to tell Mary Moriarty and Steptoe where to shove their recommendations, but my 86-year-old mother is watching me, and that prevents me. We got sworn declarations from 5 current and former troopers. Major Christopher Erickson did as much of a deep dive with respect to a use of force opinion that any expert has ever done in the country. And he did this without us paying him a nickel. I've never even met the man. And he went through and did that, sworn under oath. Lieutenant Jonathan Wenzel, Sergeant Jason Halverson, who said that the Hennepin County Attorney's Office lied by omission by quoting him in the criminal complaint. Technical Sergeant David Johnston and retired Technical Sergeant Troy Morrell. These, along with my client, are the heroes. And for the Hennepin County Attorney's Office to come out right now and say, oh, we can do it better. Here's our recommendations. Shove it. Threats. That's what these binders are here for. Everybody gets a binder today. What I heard a number of times today was Miss Moriarty talk about, oh, the threats that she's received. We just received notification here a couple weeks ago that the Steptoe law firm contacted Judge Garcia on their own without notifying us and said they received a threatening voicemail. Somebody from the court then said, you have to tell the defense this. I said, I'm shocked by this because I have received these voicemails. I never thought to bother the court with them. They called the FBI. I never even thought to call the FBI on them because I've dealt with this in previous occasions, and most of these people are a lot of talk and internet posts. But as you'll see in these binders, that's not true with respect to Ryan Londregan. He's had people drive up outside of his house and take pictures of it. He's had Mr. Cobb's brother repost his address, along with Cortez Rice, who was the same person, if you recall, that was arrested for going to the judge on the Kimberly Potter case to her condo in the hallway. The same person. And what has happened to these people? Nothing. But Mary Moriarty wants to talk about the threats on her. The first thing that I did when I found out about this case being dismissed yesterday was called Ryan and Grace Londregan, told them the news, and said, remember that go bag that I told you to pack? Go. They can't stay in their own home right now because of these threats. And now this county attorney has the temerity to try to get some sort of sympathy from you regarding some voicemails that she received. That's all I have. In summary, what I saw today at that press conference was delusional and it was unhinged. And it was remarkably unfair to my client. He deserves an apology. He deserves an adult to stand up and say, you know what? I messed up since day one. I made a major mistake. And instead, he got somebody trying to try the case in the press again at the same time that she's dismissing it. That's sick. Thank you.
Chris?
Lou.
Moriarty gave as large part of her reason for dismissing this information of what Londregan would have testified to. He didn't give a statement at the beginning. Prior to a few years ago, officers generally would give that statement in these types of cases. That kind of stopped with like the Noor case moving forward. Do you think that he should have given a statement? If you could go back and do it, do you think that she really wouldn't have charged it if he had? Just kind of give us your take on that.
No, it's preposterous. This county attorney was hell-bent on prosecuting a cop. She could not wait for a case like this to come up. And it would have made zero difference. Look at all the facts that we gave here. I have 5 sworn declarations from existing troopers, 2 other paid experts, and Noble, their own experts saying that, and she still went forward. And now we're saying, oh boy, had I known that, what I know now, it's garbage.
When did you get word yesterday?
Approximately 4:30.
And how did it come?
I got a call from a reporter.
Go ahead.
What was your understanding of whether and when the governor was going to intervene in these cases?
I got a call last Tuesday from the governor's general counsel asking me if we were still interested in the governor reassigning the case. I said 100% yes. We were then told that, listen, if this goes to Attorney General Ellison, that he's going to assign it to somebody else because of a conflict of interest. I said I was fully aware of that and that I was confident that any reasonable, independent, fair prosecutor would dismiss this case. I can also tell you that Attorney General Ellison reached out to my office on the civil matter, which I can talk about in greater detail another time. But during that call, I asked him, would you please ask the governor to reassign this case? He said he couldn't because it was the governor's decision. I then reminded him that he had done that in another case, and there was no response to that. So I don't know, to long-winded way of answering your question with respect to do I know if the governor was about to reassign this case? I don't know. It felt like that, but I don't know it for certain.
Chris, could you talk about your client's reaction to the news, and does he still want to be in law enforcement after it took place?
His reaction is the same that he's feeling today. He's shell-shocked. He watched the press conference today. He was justifiably upset with it. He was amazed at the amount of times that county attorney got the facts 100% wrong, as am I, to some degree, because I'm just frankly gotten used to it. With respect to him wanting to remain in law enforcement, this is a true public servant, and that's what he wants to do. And I can tell you that members of his family are not that happy about it. You know, his parents would like him to do something else. I think that Ryan is eager to get back on the job. I'm concerned about that, to be honest, given all these statements that are out there. I fear for the idea of Ryan Londregan pulling somebody over in Hennepin County, and especially from what I heard today about the idea that it, essentially made sense to leave a reasonable stop when somebody has probable cause to arrest somebody. But again, that's going to be Ryan's call. And right now, again, he's just lived with this for so long that it's going to take him some time to process. And in that regard, I would ask everybody that is listening and that knows and loves Ryan, just give him that space.
The county attorney suggested that he was sort of failed by his own training. I wonder what you make of that and whether he feels that he was adequately trained to deal with this sort of vehicle infraction.
He feels like he was 100% adequately trained, and I believe that training was exactly why Trooper Brett Seide is alive today.
The county attorney specifically said that MSP trainers don't train on the possibility of moving. I might be misquoting the report slightly, but they don't train on pulling people out of moving cars because it's too risky. You're saying the recommendations are ridiculous and Monday morning quarterbacking, but the recommendations also include things like maybe consider making it a policy not to reach into a car in a circumstance like this. Allow, as the county attorney said today, maybe just let him drive away. What do you make of the substance of that?
What I make of the substance of that is that I don't get into the idea of journalistic ethics and your way of your job. I don't think lawyers should get into the way of their job. I think that the Minnesota State Patrol, in all respects, has just done a phenomenal job with respect to practically every facet of their job. I think that Major Christopher Erickson in particular, by setting up those policies, has distinguished himself. I do not believe lawyers are remarkable people. We think that given a law degree, that makes us entitled to know practically every facet of human life. I'm working on a plastics case, so therefore I'm a plastics expert. I'm working on a generic drug case, therefore I know generic drugs. These people are former federal prosecutors who, in my experience, think that they know everything and they don't. Stay in your lane.
Chris, there were several hearings where lots of people showed up in support of Ryan. Mary Moriarty made some statements today criticizing that and with a reference to January 6th rioters. Is there a lot of people took offense to that? I was wondering what your thought was.
I do take great offense to that. These are people that supported a hero that was charged with murder. When did that become wrong? When did that become a problem? What have we become that you can't stand up on behalf of an innocent person? These people weren't storming Capitol and putting police officers in harm's way, putting Congress people in harm's way. To draw a comparison to that just shows how delusional this person is. This is a person that should not, underline, all caps, bold, not be county attorney. We are not, again, underline, all caps, bold, not safer with Mary Moriarty in this job. She needs to resign.
Chris, regarding Trooper Londregan's future, there is still an internal investigation with the Minnesota State Patrol. Do you foresee, now that the charges have been dismissed, that he will be reinstituted imminently? I
cannot fathom the set of circumstances where anybody, when I already have the trainers saying that he acted in accordance with his training and didn't violate any use of force policy, how anybody could say differently. He just did. I mean, again, feel like I'm Ron Burgundy here taking crazy pills. Brett Seide said, "This man saved my life." Again, does this mean anything to anybody anymore?
You had shown the number of times the officer told him to get out of the car. I know Moriarty in her press conference was talking about how wasn't explaining exactly why he needed to get out of the car. What would you say in response to that?
That's part of the training. There is part training where if I tell a person, and I'm using me as an example of a trooper, which God save all of us if that's true, but if I tell somebody, listen, you are wanted for probable cause, I have probable cause to arrest you, that will increase the chances of you fleeing. So they're taught to de-escalate, get the person out of the car, then explain. Now, you could see, and I don't know if you heard that at the very beginning, Mr. Cobb, but this was going to be another thing that I was going to point out at trial. The first thing that Mr. Cobb says, every time you all want me to get out of the car, you arrest me, but for what now? He had experience with being arrested. And again, that is something that is going to go into Trooper Seide's mind when he hears something like that, to know, hey, listen, I should not be providing so much information here to somebody because they might be fleeing. Now, again, what happened, his fears about him fleeing, it occurred. This is not theoretical. It just occurred. So, again, I just don't know how many different ways to explain this other than to say, look at the video. One of the questions I know that somebody's asked me, and I believe it was you, Paul, with respect to the reaching for the gun. I mean, again, the notion that this is somehow new information astonishes me. It's in the video. It was one of the very first things that I saw before I even spoke to Ryan Londregan. You can see Cobb's hand go up and over. The frame-by-frame analysis shows this. So, with respect to the county attorney then saying, boy, the defense gave us that was a bombshell. Do your job. Here's an idea. Here's my recommendation to the county attorney. Only prosecute people when you have the facts and the law. And look at the facts before you charge somebody. It's not particularly difficult. There's a reason why prosecutors have a high conviction rate. Sorry, I didn't mean to get mad at you, so I apologize.
Does Trooper Londregan regret anything about what happened that day?
I think like any other person, if Trooper Londregan didn't go to work that day, I wouldn't be having a press conference responding to a county attorney. So, but does he regret with respect to any of the actions with respect to Mr. Cobb? 100%, zero, none. Anything else? Thank you all so much for coming. Appreciate it.
All right, you've just been listening to attorney Chris Medell, who represents State Trooper Ryan Londregan. He made it very clear since day one that he felt Londregan should never have been charged by the Hennepin County attorney in this case. He also questioned how Hennepin County attorney Mary Moriarty went about her initial decision, specifically when it came to not using use of force testimony. He also acknowledged that he was contacted last week, as early as Tuesday, by the General Counsel for Governor Tim Walz, exploring the possibility of perhaps reassigning this case to the Minnesota Attorney General's office. So let's listen in right now to Mary Moriarty's press conference from earlier this morning as she explained her decision to dismiss this case.
Time after time after time, our Black community is told there can be no criminal accountability because of system barrier after system barrier after system barrier. And they rightfully ask leaders, what are you going to do about those system barriers? Heated debates about minor policy changes ensue until the next Black man is shot by police. And the family and the community is told once again about the system barriers preventing criminal accountability. The same barriers that were there last time. This morning, I am here to talk about some of those system barriers in the context of the shooting of Mr. Cobb by Minnesota State Trooper Ryan Londregan. My intent is that leaders here in this state find the political courage to remove these systemic barriers. I first want to acknowledge the Cobb family. They continue to grieve a devastating loss amid a political circus that has repeatedly tried to center Mr. Londregan as the victim. The defense team, paid for by the Minnesota Police and Peace Officers Association, encouraged over 100 supporters to be bussed in, handed out free support Londregan t-shirts, and created a gauntlet downstairs that the Cobb family was forced to walk through to get to court. Some of them taunted Ricky Cobb's twin brother, Rashad. Members of our staff were frightened at the spectacle, which reminded them of January 6th. How is this behavior acceptable? How is that behavior acceptable? Where is our humanity for the Cobb family? Where is the respect for the trauma that they and the community have suffered? Because make no mistake, Ricky Cobb was the victim in this case. Ricky Cobb should be alive today. And that makes our inability to move forward even more difficult for Mr. Cobb's family and for our community. And for that, I'm deeply sorry. In January, the Hennepin County Attorney's Office charged Mr. Londregan with the death of Ricky Cobb based on our review of the evidence that existed at the time. This includes the BCA investigation, which was hampered by the refusal of members of the Minnesota State Patrol to participate in interviews. We saw the videos of the incident placed in a format allowing simultaneous comparison of the 3 body cams and the dash cam. And we reviewed supplementary witness statements made in the grand jury investigation. We believed then, and we believe now, based on that evidence, we made the correct decision to charge Mr. Londregan. In fact, several weeks ago, the defense withdrew their motion challenging probable cause. So as it stood Friday, before we made this decision, we have a clear path to trial. And the easiest political decision for me would be to go forward. But we have chosen not to do that. And I'm going to be talking to you about why. There's been much speculation about why we brought in a firm from out of state to prosecute the case. The truth is that these cases are considered by many prosecutors across the country to be, quote, career killers because of the potential retaliation against them by law enforcement. In fact, before I got to the office, that happened. That our prosecutors who prosecuted law enforcement, some of them received threats and were retaliated by law enforcement. And so prosecutors across the country, including here, fear they cannot do their jobs because of retaliation by law enforcement. None of this is acceptable. The Minnesota Police and Peace Officers Association, MPPOA, the same organization that opposed a rule which would prohibit law enforcement from belonging to white supremacy groups, paid for 3 private lawyers to represent Mr. Londregan. And he has a right to a good defense. We were frequently peppered with motions with little or no basis in law or simply factually inaccurate. But we still had to respond to this manufactured busywork. I've mentioned that we are down staff, particularly in our adult prosecution unit. So we were not able to assign the number of prosecutors and staff needed to respond to these tactics. One of our experienced prosecutors said he had never seen anything like this before. The same day we announced charges, the defense posted a video attacking me personally as being out of control and declaring that there was a war on law enforcement which was going to end in this case. I felt personally threatened by that video, but as the case went on, I came to realize that their strategy essentially was to use scorched earth tactics to attempt to intimidate anybody involved in this case or anyone who might consider trying to hold a police officer accountable in the future. And this is a strategy that is being used across the country, which I know from talking to prosecutor colleagues. One expert in this case said that he felt personally threatened by the defense. An example of their motions, one of them, you remember they accused me of prosecutorial misconduct for misusing the grand jury process. They claimed falsely that we asked the grand jury to make a decision to indict, and when they didn't indict, we discharged the case ourselves. That never happened. It never happened. They quietly withdrew that motion once it no longer served their purpose, but that got buried. That got buried after it was the lead. It was after headlines because of the governor's involvement, which I'll talk about later. Some people said, well, why didn't you ask other prosecutors' offices in the state? And the truth is they are very short-staffed. When we have conflict cases, we often have to figure out which other office can handle it because they just don't have the capacity. And this includes Ramsey County. No one else we contacted in Minnesota wanted to be the recipient of the defense attacks that they knew would come along with this case. Now, that could have been the end of it, not being able to find anybody in Minnesota who wanted to be the subject of these continued attacks. But we didn't give up. We didn't give up at that time because we believed we had rightfully charged him and that we had a case which we could prove beyond a reasonable doubt. So we brought in the attorneys from the Steptoe law firm, all of whom had been federal prosecutors at one time. We provided them with all of the information that we had at the time. After their review of that information, they agreed that it was appropriate to charge Mr. Londregan in the death of Ricky Cobb. So they did agree, and let me make that clear. For former federal prosecutors agreed that it was appropriate to charge Mr. Londregan. But we also told the defense team at that time, and from the beginning of this case, that we would review any new information that they wanted to provide us. And this is an offer that we make in every single case we charge in this office. This is part of my commitment to transparency, accountability, and justice. All investigations are ongoing, even at times during trial. When new evidence becomes available, we evaluate our cases based on that new information. When I became Hennepin County Attorney, I emphasized to our staff that ethical prosecution is constantly assessing our cases and evaluating whether we can or should continue to move forward. In the last weeks, the defense has presented 4 witness declarations containing new information. And for the very first time in court, revealed the substance of Mr. Londregan's prospective testimony. So what they said in court about what Mr. Londregan would say if he testified, and I'm just going to talk about 2 parts of it. One was this, that Mr. Londregan shot Ricky Cobb because Mr. Londregan feared that Mr. Cobb was reaching for Mr. Londregan's gun. I want to make it clear here because there was a misstatement in the press. No one's ever said, the troopers have never said, that they were aware of any gun in Ricky Cobb's car or that he was trying to reach for that gun. That gun that was found in the car well after this happened is irrelevant to this. What Londregan's attorneys said he would testify to was that he thought Mr. Cobb was reaching for his gun, Londregan's gun. That's something that they had never said before, never told us before. So we went back and we looked at the video over and over in slow motion. And what you can see from the video is that Mr. Cobb's hand at some point does come up. My guess, by the way, is that because Londregan opened the door, pointed the gun at him, and started screaming at him, that his hand was coming up to protect himself. But the video doesn't prove that, and it doesn't disprove what Londregan says. One of the other things that I think is of note of what Londregan's lawyers say he would testify to is this. If you slow down the video, you will be able to see, and I think at some point we'll be able to release this, Seide reaches into the car, and he is essentially draped across Mr. Cobb, trying to unbuckle the seatbelt. What Londregan's lawyers said he would testify to is that in that split second, he realized his partner was draped over Mr. Cobb, and he carefully fired 2 shots into Mr. Cobb's torso so that he wouldn't hit his partner. Now, as to the believability of that, I won't comment, but I will be talking about how that did change our perspective here. The declarations that we got from state trooper trainers, which we hadn't seen before, went to their training and lack thereof, and I'm going to get to that later on too. It was frustrating to learn of this new evidence so far into the case because the defense had so many opportunities to provide us with it. We even offered Trooper Londregan immunity to come on in and tell us his story with the agreement that we would not use that statement if we decided to go ahead with trial. The Steptoe lawyers called that agreement, they call it in DC apparently, Queen for a Day. And it simply means, Londregan, come on in, tell us what you have to say about this so that we can consider it when deciding whether to charge. And if we decide to go forward, we won't use the statement that you made. He refused. He refused to do that, which was his right. But we also didn't know what he was going to say. So we certainly talked extensively about how improbable some of Mr. Londregan's assertions were, especially coming so late in the process and with access to all of the videos. We also talked about the barriers, the reality of the fact that Many of the law enforcement witnesses in this case got lawyers, even people who had no or were not subject to any criminal liability at all. And they were represented by the same pool of lawyers funded by MPPOA. So many would say, why not cross-examine Mr. Londregan and argue to the jury that he wasn't being truthful? Once an officer says that he used deadly force to prevent imminent great bodily harm or death to himself or others, we then, the burden shifts to us, beyond a reasonable doubt, the highest standard in the system, to prove that that was not true. And the expert witnesses in use of force cases focus pretty much only on those seconds when the shots happened and what a reasonable officer could have perceived. So when we got this information, we had to assess what it meant for the case. And we took the new evidence to a use of force expert whose analysis led us to conclude that based on that new evidence, we would no longer be able to succeed at trial. So why is that? And why wouldn't we just go forward? What happens in trials is this. We present our case. And because the defense had the, what we call, affirmative defense, in other words, they were saying, yes, we did shoot and kill Ricky Cobb, but we had a legal excuse. And that legal excuse was justified use of deadly force. And so we were going to have to prove beyond a reasonable doubt that that wasn't the case. Now, we would put on our case